So it depends on how you would define castle doctrine, but between 38 and 40 states have it codified.
Have it codified.
Yeah.
So in the United States, the castle doctrine is a principle which has been established through case law over like hundreds of years.
Yeah. Going back to like the 13th century or the 14th century. It's common law.
Brought over from Europe, of course.
Right. And then some states have codified it. And Colorado, for instance, in the 80s had a Make My Day law. It's like a...
Yeah. That's a good one.
Clint Eastwood,
yeah.
Right?
Tell us about that for a second.
Clint Eastwood or the Make My Day law?
Both. Go ahead. Tell me about Make My Day law.
Go ahead and make my day, right? The idea is that you have the right to shoot and kill. So if someone's in your home at that point, the presumption is that you're entitled to shoot them because you're in imminent danger.
By being in the house, there's a natural presumption that your life or others who are in the home is at risk.
Yeah, you don't have to prove it. It starts with the presumption. Whereas in Canada, it goes into the analysis of, were you justified? Were you in fear? Was the fear reasonable, objectively speaking, and so forth?
By way of introduction, everybody, this is Alper Yilmaz. He's our articling student who started yesterday.
Right.
It's on
Time
the podcast.
Flies.
Time flies, eh? Congratulations, you're on the podcast.
Thank you. Long-time listener, first-time caller.
That's great. I like that. And we're also joined by another special guest. This is Mr. Stay Puft. Michael Burry's not able to join us, so Mr. Stay Puft has.
No correlation.
And just
no
so
relation.
You know,
at all.
one of the most no correlation whatsoever. But one of the most important questions I ask to any prospective articling student or associate at the end is, I point to the Mr. Stay Puft and I go, "Do you know what movie he was featured in?"
Ghostbusters.
Automatic hire. Okay, so it won't come as a shock that in Canada there has been a lot of media attention in the last few weeks to the law of self-defense, references to the United States about the castle doctrine that Alper was talking about, that we should adopt principles from the United States like the castle doctrine, that some people who may be politicians have said that we should follow the United States in this regard, assuming that, in fact, it's just standard across the United States, and it's not. And I gave some public commentary, and there were a lot of good questions and a lot of not good questions. And I just thought it's appropriate because we just had another tragedy where on a home invasion in Vaughan, a man was killed during the home invasion in front of one of his children. And we don't know the full circumstances of that actual home invasion. The house was targeted, but we don't know more. But these tragedies are garnering a lot of media attention right now, and they are extremely tragic. It's horrific to anybody who would be in a home. That is, the ultimate fear, that a home invasion occurs and your children are at risk. The most vulnerable, your 4-year-old, 5-year-old, most vulnerable victims you could ever think of. And so I think it's important, though, that we take a step back and examine our laws. I've tried to get this across in some of the commentary I did, so that we are not always jumping to the conclusion that our criminal law is broken, because it's not. We have some, crime happens in any city that has, when you look at the 𝐔𝐇𝐎𝐒, we have more than 5 million, maybe like 6 million people in the general area. You're going to have crime. And some of the crime is going to be really bad, just like it occurs in the United States and other places. So I think it's important for us to just take a step back and let's examine self-defense laws in Canada and do a little bit of contrast to the laws in the United States about the castle doctrine and what states have it and what states don't. And just keep in mind that the premise of what we're suggesting about self-defense, I hope that we get across is that to our viewers and whoever else is interested in this, that it's a very broad law that has sufficient safeguards to deal with a homeowner who has to repel a danger that happens within the home. I want to remind everybody that the current self-defense laws came into force
2012?
Pretty close. March 11, 2013. They were introduced in 2012. Very good. You must have gotten A in criminal law.
Yes.
Okay, just say yes. And that was under the Harper government. And that was because there was some concerns that the previous provisions were overly complicated. So the new provisions were supposed to streamline the analysis for self-defense, and it was brought in under a conservative government. So you can imagine that, of course, their act was in furtherance of protection of the individual, not the so-called criminal. So it was called the Citizens Arrest and Self-Defense Act because there was also amendments at that time to a citizen's arrest. And at the core of the new defense provisions was a very simple requirement, frankly, that the accused conduct be reasonable in the circumstances. And the section of the Criminal Code is Section 34 sub 2, and it requires the courts to consider a non-exhaustive list of factors in determining whether the accused actions were reasonable. The provision is otherwise not dispositive in the sense that all these factors have to be considered, none of which are dispositive, and that there is a lot of leniency and flexibility. I think that was the term that I was looking for, to deal with a myriad of factors that are at play when somebody's acting in self-defense. So it's important to remember when we talk about our self-defense laws, and whoever may be criticizing these self-defense laws now, these were brought in under the Harper regime where there was a strict focus on protecting Canadians. Okay, with that said, I'm going to bore you a little bit more. So let's just talk briefly about what self-defense law is in Canada. So under Section 34, a person, whether you're in a home or not in a home, has the right to defend themselves if on reasonable grounds force is being used against them or another person, like a child or somebody in their company, a girlfriend, a fiance, congratulations, by the way, or a wife. Hi, Marcy. And that threat of force is being made against them or another person. The act that constitutes the offense is committed for the purpose of defending or protecting themselves or the other person, and the act committed is reasonable in the circumstances. Pretty easy concept. So if there is somebody who is threatening a violent act or about to commit or is doing a violent act, the individual who is seeking to protect themselves or someone that they care about who's with them is allowed to use reasonable force to defend themselves. Pretty simple concept. And that's very flexible. The criminal code sets out factors, but before I get into them, if somebody is charged with an offense arising out of an altercation, the defense is self-defense. Once there is evidence produced, either through cross-examination of the Crown in the Crown's case, or through testimony of the individual who's charged, the accused, the onus is on the prosecution to prove beyond a reasonable doubt that the force used against, let's say, the intruder was disproportionate. So as long as there's an air of reality, it's a legal term, and it's a very easy threshold. Somebody can testify and say, they broke into my home, I thought they had a knife, they were coming right at me. That gives an air of reality to an individual having to act in self-defense, okay? And then once that's achieved, which is a very, very low threshold, the onus is then on, you're really good because you're nodding. It really helps me as I go along. You got to have her for every episode. Good work, Sarah. The onus is on the prosecution to disprove beyond a reasonable doubt that the force used was disproportionate. That's a pretty significant threshold. And of course, when police are investigating a crime, a home invasion, and then thinking about charging the homeowner, they're taking into consideration many factors, including the provisions of the criminal code. The factors that are listed under sub 2, in determining whether the act committed is reasonable in the circumstances, the court shall consider the relevant circumstances of the person, the other parties, and the act, including but not limited to the following factors. Okay. My phone never stops beeping. The nature of the force or threat, the extent to which the use of force was imminent, and whether there were other means available to respond to the potential use of force. Can you take it from C? I need a sip of
Sure. The person's role in the incident, whether any party to the incident used or threatened to use a weapon, the size, age, gender, and physical capabilities of the parties to the incident, the nature, duration, and history of any relationship between the parties to the incident, including any prior use or threat of force, and the nature of that force or threat, any history of interaction or communication between the parties to the incident, the nature and proportionality of the person's response to the use or threat of force, and whether the act committed was in response to a use or threat of force that the person knew was lawful.
Great. So these are a lot of factors the court has to take into consideration. Not one or any combination of them is dispositive. And in fact, the court can take into consideration other factors that may be raised in the case and unique. Very broad flexibility. Now, in Canada, we don't strictly have what they have in the United States, which is referred to as the stand your ground law. So the stand your ground law in the United States says you can absolutely stand your ground if you're facing any type of threat or imminent force. We do not in Canada have a duty to retreat. So I want to be clear about that. These are subtle differences. If you're faced with a threat of force that you believe will cause harm to you or others that you care about, you're allowed to repel that force. You don't have a duty to retreat. However, if somebody is charged, there will be considerations as to what options were available at the time for the person who's charged, the accused. Let's say, let me use the example of the homeowner, because that's what's on everybody's mind now. Were there other options available to that individual rather than confrontation with the intruder?
Including retreat.
Right. So this is important. So it's an option that can be considered, but there is no requirement to retreat. So it's a subtle difference. And I think it's important to consider certain scenarios. An individual breaks into a home. It's 2 a.m. The homeowner comes down, sees this individual, and yells at the individual. The homeowner grabs a baseball bat that happens to be in reach. The intruder turns and starts to exit the house, gets to the front porch. The homeowner pursues the intruder and hits the intruder over the head as they're trying to go down the stairs from the porch to exit the property, striking the individual, the intruder, and they are unconscious.
It's almost certainly murder.
But let's say they're not dead this time.
Right, well, it's
They're unconscious, but they're seriously injured. Has there an offense possibly been committed by the homeowner?
Right, the question is whether it's self-defense or not. And so the idea that they've turned around and you're hitting them from the back, it's not very defensive.
Optically, it's not a good look, right? But again, it's not a fait accompli. In other words, all sorts of factors have to be taken into consideration. So the person who's the homeowner who may be charged in these circumstances with an assault bodily harm, or aggravated assault, depending on the extent of the injury, or if the person dies, manslaughter or second-degree murder, there can be factors to take into consideration. And there is a subjective element to the fear that is experienced by the homeowner. But we do have, and I'll get into this a little bit later, sort of an objective reasonableness to this belief. In other words, what would a reasonable person in similar circumstances do? So there is sort of a modified subjective objective analysis. But a person could say, well, I thought there were more people. It was dark at night. I saw him leaving, but I thought he could have come back. I'm completely terrified. I have experience from being attacked before. These can be factors that can be included in a defense to try and deal with and mount a successful self-defense argument. And it may very well be that it would be successful. If you're asking me as just an objective lawyer, if somebody's exiting your property, they're clearly leaving, and you're not seeing any other individual around, they're not brandishing a weapon at you, and they're leaving, and you decide to pursue them and then beat them over the head with a baseball bat, that is an inherently unlawful act where somebody is being struck from the back. At that point, they're essentially unable to defend themselves. And it's not necessary in the circumstances. You could have shut the door, locked it, gone on your cell phone or on the home line. I still recommend people have home lines. And I do. And call 911. There are other circumstances where there may be an opportunity to get out of the way. This could be a situation where you're not in a home, but you're in public, and due to certain circumstances, rather than confront the individual, you may be able to step back and remove yourself from the actual threat. These are all things that get considered. I don't think there's anything unreasonable about this.
Right, two words that often come up, right, is proportionality and necessity. Was it necessary? Was it proportionate? So if they're
Talk about that, and talk about it slowly for a moment, okay? So break it down.
already leaving your home, they've turned around, they said, okay, I'm out. Or they don't say anything at all, but their back is turned to you and they seem to be exiting. It's not necessary. Now, proportionality, similar but different. If they're throwing rocks at you from outside and you take a shotgun and shoot them, it's disproportionate. Sure, they've assaulted you, but you're not defending yourself at that point because it's disproportionate. Maybe not because it's unnecessary. There might have been something less that you could have done.
Yeah, and you can take in all scenarios. Let's say somebody's on you raise an interesting. Somebody wants to intimidate you for some reason. They come to your home. They're doing something aggressive on your property, and you want to confront them about it. Well, there very may well be a feeling that you are being intimidated, you're under threat, and more is going to happen. And so you may feel that you have no choice but to confront them, to repel them. But all sorts of opportunities may be available to do other things. Call 911 at that time. Don't go outside if they're not approaching, if they haven't broken a window. There are all sorts of factors that have to be considered. That's why our laws are drafted in a way that's not overly complex with respect and have greater flexibility to do with a myriad of circumstances.
To the intimidation point, one of the factors is, do you have a previous relationship with this person? Were there previous threats of violence or uses of violence? So the context does get worked in, right?
The context of every case will stand and fall on its set of facts. So every case has to be analyzed in its own particular circumstances. So you're right. But generally, in any type of self-defense case, there are more factors that can be considered other than those which are within the criminal code. I just want to expand for a moment on what was I talking about when I'm saying how do we measure what is proportional, what's reasonable in the circumstances. So there's a number of Supreme Court of Canada cases. One is Hodgson, HODGSON. It's 2024 0712. The exact citation is 2024 SCC 25. So it's a Supreme Court of Canada judgment. It's a case where people were at a house party, and I think alcohol and drugs were being used, and one individual was perceived to be posing a threat and asked to leave the premises and didn't, and another individual stepped in to restrain them and put them into a chokehold in order to contain them, and unfortunately the person went unconscious and died. And that was another decision in line also with a case called 𝐓𝐇𝐈𝐒. Am I pronouncing that right?
Kill. An unfortunate last name in that circumstance.
�KHILL, 2021, 2 SCR 948. But what the court notes is the accused must have subjectively believed that the force or threat was being used against their person or against that of another. However, the accused belief must also be held on a reasonable grounds basis. In order to assess the reasonableness of the accused belief, the trier of fact will apply a modified objective standard that takes into account what a reasonable person with the relevant circumstances and characteristics and experiences of the accused would perceive. Let's pause on that for a moment. Reasonable person with the relevant characteristics and experiences of the accused would perceive that the accused actual belief must be held on reasonable grounds imports an objective component to ensure conformity with community norms and values, weighing the moral blameworthiness of the accused actions. So this is important. So let's talk about this for a second, okay? This episode is sponsored by EasyDNS. EasyDNS is a domain name, registrar, and host that has a 30-year track record in the domain and web hosting industry. Whether it be cancel culture, platform attacks, or nefarious actors online, move your domain and web hosting over to EasyDNS, one of the most secure web hosting services, and help support Not on Record in the process. All you have to do is go to easydns.com/notonrecord, or when you sign up at EasyDNS, use the promo code NOTONRECORD at checkout. Thank you, EasyDNS, for your support of Not on Record. And now back to our podcast. Thank you. So what does it mean to you, Alper, when the test involves relevant characteristics and experiences of the accused?
Right. So it's objective, but objective to the person in question. So it changes, it varies depending on case to case. So if you're 5'1" and somebody 6'4", 250 pounds comes at you, you're going to be given a little bit more leeway. The idea that you're afraid for your life and in real danger, it's easier to substantiate, and the law recognizes that.
So what you're saying is, so let's take physical characteristics into consideration. The intruder or the aggressor is much larger, appears much stronger than the person who's the recipient of the threat of force. That's one characteristic.
Right. I believe it came from 𝐕𝐈𝐃𝐄 when the court acknowledged that women are, you can't use an objective standard which uses men as the benchmark for women, because women will fear in different ways. That's what Justice Wilson said at the time.
Right. So you can have a situation where you have a woman in a home. She's the victim of the home invasion, and is able to try and repel that force herself, but she is in a certainly a very vulnerable situation to somebody who might be very large and strong. So that's a personal circumstance which is subjective to the actual homeowner, and I keep saying homeowner, I'm sort of excluding other circumstances, but that's a personal characteristic, so it's a subjective element.
But even, I guess, the fact that it's in the home itself is a factor, right?
It is.
You're more likely to be afraid in your home. It's the middle of night, you're more likely to be afraid as well.
All those things are relevant. So those are circumstances but I want to just talk about the characteristics and experiences of an accused. So this is really important. This personalizes and makes subjective a large part of this analysis. And people may have certain experiences that predispose them to perceive a threat different than somebody else. Let's imagine that you have grown up in circumstances where there has been a tremendous amount of violence around you. And the slightest noise or threat of violence can spark extreme fear. Some people may suffer from PTSD as a result of a history of trauma or abuse or experience to war in another country if they came here. That may predispose them to experiencing that fear in a different way than another individual would. And so the law is flexible enough to take into consideration the personal experiences and circumstances of that individual. It may require some psychiatric evidence to establish that they had been suffering from something. This was related to past experiences and trauma. But this is very important. It does not you're not a robot. And in the circumstance, I should say this, I don't know if I said it before, when assessing the reasonableness or the proportionality, we're not required, a court's not required, an individual who's acting is not required to do a fine analysis of the actual force they're using. You can't in those moments, okay, so that's a knife, I can use a slightly larger knife, but not one that's serrated. You don't have to do that. That is, impractical. So we don't have a fine measurement of the proportionality in a particular case. But I think it's extremely important to note that in a test of of self-defense, there's a very significant subjective element. And there's absolutely nothing wrong with the objective component, in my respectful opinion, of what a reasonable person would have done in similar circumstances. Because that, if you're in front of a jury, 12 regular citizens, they will be feeling, in many respects, they may be feeling exactly the same as the accused felt. Or they may simply step back and go, there was zero reason for the person to act with such excessive force. So you can imagine, going back to the home invasion again, an intruder walks in and has not brandished a weapon and may be approaching, but gets disheveled because they are now met by the homeowner, and they have a large Doberman, and that's growling, and they stop and they freeze, and then the homeowner decides to use a weapon on the intruder. Well, in those circumstances, it certainly could be excessive force because the person is now frozen, has no weapon. But it may very well be that it's not excessive. We have plenty of flexibility within these laws. Now, I think I've laid out the self-defense laws in Canada. I'm trying not, I could go through cases by case, and it's not really helpful for this discussion. But there is a lot of flexibility. The police will also engage in this type of analysis when they're considering whether laying a charge. And it's not like you hear this all the time. In addition, because there's been a lot of comments made out, I'm just going to talk about this, and then I'm going to turn over to you for a moment, Alper, okay? I'm sorry to occupy so much of this time.
No, please.
With your debut on Not on Record, and you're starting to article here, you poor soul. I want to protect, to a certain extent, the integrity of the rule of law in Canada and the integrity of our system of justice, because it's often said by individuals that it's broken, and it's not. We can tweak certain things. We absolutely can tweak certain things, 100%. And you will hear on this podcast that we complain often about wrongful accusations, wrongful convictions, tainted investigations, inadequate investigations. Let's keep all of that in mind. But Mr. Poilievre, who's the leader of the Conservative Party, who on many policies and issues I agree with, I'm not going to disclose my political stripes, conservative, but had suggested that the use of force provision within the criminal code could be amended such that there is a presumption that a person is acting with reasonable force when somebody comes into the home, that they automatically pose as a threat that presumes reasonableness. That's similar to what they have in the United States with the Castle Doctrine. The reality, again, though, I want to say is it really doesn't do much because there's a lot of flexibility under our current law. And if somebody's charged, they raise their fear based upon their personal characteristics and their experiences and what was objectively discernible at the time. That's just an air of reality to it. It's up to the prosecution to prove beyond a reasonable doubt that their actions were not proportioned. That's a pretty high standard, a pretty high burden for the prosecution to meet. Okay, let's shift to you for a moment. We're not experts with the United States. Let's talk a little bit more about the Castle Doctrine, okay, and why, for some reason, it's so attractive in Canada.
Not experts
at this particular
on US
time.
Law,
We're not experts in U.S. law. We know about it.
Doesn't seem that different from what we have.
And you started off by saying some states have provisions within their codes that are very similar to Canada.
New York, for example. Yeah.
So let's talk about New York for a moment. And if you need to go to the Google, go ahead.
No, it's okay. New York has a much narrower version of I call the Castle Doctrine as if it's an explicit law that's codified, but their application of these principles is much narrower than, say, Florida. So in New York, it's very similar to our law. It has to be proportional and it has to be reasonable. And again, you arrive at the same factors. Maybe they're not enumerated in the same way in their statute as our statute, but you kind of arrive at the same place.
Yeah, so this is interesting. So let's remember this. In the United States, criminal law is both federal and state. So there are federal criminal statutes, and that governs federal crimes, which go over state by state. For example, certain drug cases, fraud, etc., which are cross-border. And then there are state statutes that deal with laws within the state, which include murder and other things. And each state can have different criminal laws. Ours is federal, one criminal code. I love it. This is why I loved criminal law, because there's one book to look at the time. And it's standard throughout Canada. United States, it changes from state to state. So like Florida, for example, has a much more sort of strict
So they start
doctrinal view of castle law.
So they'd start with the presumption that it was reasonable based on the fact that they're in your house, whereas we take
And you can use
lethal
force
force
up to lethal force.
up to lethal force, right? So whereas they start with the presumption that it was reasonable, we hold that possibility open, but you have to take the steps to get there, and those were the factors that we went over, such as the personal characteristics. And maybe this is why it seems to you, Joseph, that the media is making a big fuss out of this, but the fact that it's in your home, it's a very significant factor.
100%.
Right?
We're not here to promote policy, and I'll come back to this in a second. So in the United States, let's just do some takeaway principles, okay? So different than us, there's a firm principle of no duty to retreat. So a person attacked in their own home or on the streets has no obligation to retreat before using force. Whereas, like we have here, you don't have an obligation to retreat, but if you had other options,
That varies state by state, if I'm not mistaken.
I think it's pretty much standard in the United States that even from state to state, there's no duty to retreat. But what will happen from state to state is the force use proportional, like you spoke about. Presumption of threat. In many states, if someone is unlawfully entering your home, like you've referred to in Florida, it presumes the threat of death or serious harm, justifying the use of force up to including deadly force. And as we've noted, some U.S. states extend the principle beyond the home to the workplaces, vehicles, or even other places where a person has a legal right to be, sometimes called your stand ground laws. But I want to shift to say you don't have a duty to retreat in the United States. But to stand your ground laws are different. That may vary from state to state. The rationale, if we're correct, the United States is it's emphasizing individual and property rights and individual autonomy, giving broad protection in the case of home invasions to homeowners against intruders. This is very attractive now to people who think our system is broken in Canada. I don't know. What do you think?
I mean, I love private property as much as the next guy, but it doesn't seem that far off from what our law already is. We pose the question and we have to go through the analysis, but many of the states also do. And I mean, the analysis is still there. I think a jury or a judge is always going to find it compelling that it's in your home. So just because you don't begin with the conclusion doesn't mean that the conclusion is foreclosed or impossible to arrive at. So it does seem like maybe we're exaggerating the difference or making it seem much worse than it is.
I agree. And again, that's why I came back to what the legislation was back when it was enacted in 2013 under a conservative government. The impetus was to streamline, make this much more easier to understand, and for the protection of Canadians and the protection of your rights to protect yourself against force, including use in a home. But there is tremendous flexibility in Canada. This is clearly an issue that's up to debate that can be dealt with, through elections. I mean, we have elections. We just had an election. We have a liberal minority, but just barely. They're pretty close to a majority, a few seats shy. And so this can be an issue next time an election comes around as to what the public wants. And the public will can be expressed. And that's something that can be expressed to the politicians. And if it results in legislative change, so be it. That's the will of a democracy. And that's how it works.
It's a very emotional issue, right? Which I think is why it's coming up.
That's a good point. So we live in a time now where everything is so immediate. You just go to your phone and you will get the news, and you will get news flashes of homeowner shot in front of his child.
You got to turn those notifications off, on your phone. It's not good for you.
I can't. It's just, I'm too addicted. But we live in such a time of immediacy that it's in the media, it's on your social media, it's out there all the time. And so we will have this overwhelming presumption that is going crazy, and it's not always that way. And these are tragedies and these are bad circumstances. In the case in the in the Lindsay area where the homeowner is charged, we have to wait to see how the facts unfold before we make a judgment. That the police felt that they had grounds to lay a charge. He's going to be well represented. It will be dealt with. The Crown will be carefully reviewing it, and we'll see what happens.
It's true. We don't really know anything about it, which is the surprising thing, right? Based on how much we've spoken about it and heard about it.
And again, I like, this is why I like Canada versus the United States. I don't like cases tried in the media. In the United States, the indictment would be, unrolled in a press conference, and everybody would know everything about the entire case. We know a little bit because the homeowner has been charged, and we know from the court information what that says, that there was a weapon, it was a knife. We know that the intruder was charged. They were out on bail. Everybody's pissed off about that. I understand that. And he had a crossbow, apparently. So just on those facts alone, you might go, well, why is he even charged? I understand that. We have to wait. There's obviously further information that we don't know. What I don't want us to do is to jump to conclusions about what legislative changes we should make to the criminal code based upon circumstances where we don't have a full grasp of the facts.
Well, we don't know what the court's going to decide or how the analysis is going to go because we don't have the facts yet.
No, but we clearly have a situation now in Canada where this person should not have been charged at all. The people have made comments that what the law is broken. They should not have been charged without knowing what the facts are. And even the police in that region had to come out with some sort of a very limited press statement because of the public pressure about it. That's unusual.
I suppose it begs the question, are there any circumstances in which someone should be charged?
Yes.
And
we don't know what happened.
I'm surprised. I don't think anybody would go that far.
Well, you'd be surprised because I was looking at commentary when I had gone on one podcast and tried simply to just explain the laws. And in the commentary, there were a lot of people that were expressing the opinion that it should be just a strict law, that if somebody enters your house, they are presumed to be a threat and you can use lethal force.
That's not even the case in the United States, though. There's still exceptions, right? You can't shoot your guests.
Right.
You can't shoot your family or someone who has a lawful purpose for being in your home. Like if a UPS guy knocks on your door, you can't take him out with a sniper rifle from the attic.
Right. I mean, so we're going to the extreme on that. But what I was getting from the messages was that if you have any intruder, so somebody who is not supposed to be there, not lawfully has a right to be at your front door or to enter your property, somebody who's a true intruder, under those circumstances, you can use lethal force, period, and should never be charged. I think that is too strict. I think it's too dangerous. I think it can lead to unintended consequences where we could have unintended homicides that would be protected under that type of legislation. And in fact, there are studies in the United States, which I ran across, some interesting studies, that said in certain jurisdictions where they have this very dogmatic approach to the castle doctrine, there have been instances of people not being charged or being acquitted where clearly it was either a manslaughter or a second-degree murder. And so I think there's a lot to be said for how this legislation is drafted in Canada. It is flexible. It is good. It's important for us to take a step back, let a process unfold so that we understand more about the facts. And eventually we will know more about those facts. And it may be, I'm not saying this is going to happen, but it may be with the case in Lindsay, the Crown is certainly going to be doing a review of the case. They always have to do a reasonable prospect of conviction. Certainly there'll be pressure on them to do that. And they'll have to do that in a judicious manner. I've had my complaints before on this podcast about Crown's not always exercising that analysis in an appropriate way, but I'm sure they're going to try and do it. So we just have to let it play out. I think it is healthy for our democracy to have debates about what's appropriate laws, what we need to do to protect innocent people who are in their homes, including children and the elderly, etc. I just think we have to be careful about shitting on our system without knowing more. We do have a good system in Canada. And I think our laws, to a large extent, have been carefully drafted. And I think, like I've repeated numerous times, that they are so flexible, it takes into consideration a myriad of factors that can protect a homeowner acting in self-defense for themselves or their loved ones. Do you have any closing words?
Don't forget to like.
Oh, I didn't even have to prompt you.
comment, and subscribe,
And share.
and share.
How long did we run on this?
40 minutes.
Oh, wow. Okay. So hopefully this was helpful to everybody. We invite the comments. So, as you know, when we get comments or emails, we like to respond to them. I thought this was just a timely thing to speak about. So thank you. If you have questions, please post them up when this drops or email us. We always want to get your input and then respond to it. So thank you and have a good night. Alper,
This was
thank
fun.
you.
Thank
Right
you.
on, man. To many more podcasts.
To many more.
Okay. Good night. Thanks, Sarah, for joining us. Good night, guys.